Well, hi there, and welcome back to another episode of Let's Talk Real Estate Investing. I'm your host, Sharon Vornholt, and I'm so happy you're tuning in today. Today, I have a question from one of the listeners who also happens to be a student of mine, and it has to do with the big question of do probate properties need court approval to be sold? So this is a yes answer. The basic answer is yes. The probate court would have to be involved in this, but does she need some? Do they need some other special kind of, court approval? And the answer to that is no. The probate court will take care of this. But let me read this question to you because it's really kind of a complex situation with several different things. So she says she's just finishing up my course, Probate Investing Simplified. And she's also a realtor, but she's never done probates. And now she has an opportunity to buy this property. It is a 3-bedroom duplex with no HOA fees. So she'd like to buy it and keep it as a rental because it has good, cash flow potential. So it's an inherited property. And she says the listing agent says the sale must be approved by the court. They're thinking this is something other than just the probate court, though. He says the seller can close soon, but there's a tenant in there who's not allowing any showings to the seller, not letting the seller in, which is kind of an unusual thing. They're not letting anyone in, but the seller just wants to sell and does not want to get involved with the occupant who's a family member. So the occupant is currently not paying rent, only keeping up the utilities. They refused $700 for cash for keys. They just want to stay and live there rent free. So the tenant is not cooperating. And she's asking, should she stay away or try to negotiate? Well, I've been doing this since 2008. And all that time, I've never heard of the sale needing special approval by the court. This person is in Illinois, other than what is normally done through the probate court. Now, you remember that the probate court is in charge of all the things to do with the estate. So yes, technically, they will sign off on the sale of the property. But since I've been doing this since 2008, I've not once had them question a price or an appraisal from the court. That's been my experience. Now, I would say to check for in your area because there are little nuances from area to area, but basically the process is the same. Now, if you've taken my course or watched any of my videos, you've probably seen that I have special language in my probate, in my sales and purchase contract for probates. And that language came from my attorney, my real estate attorney, who is also an investor. And in there, that languaging says you would normally say, I will close between this many days and this many days. And in this case, you're going to add something to that. So I'll make up some days here. Closing will be no sooner than 7 days and no longer than 30 days upon court/attorney approval to close. What this means is, yes, it does have to go through the court, go back to the probate court, and they're just going to sign off on it. Now, I know if you are in California, they have some different nuances there. There may be a case where there has to be an appraisal. I have never, ever encountered that situation in 15 years. So that is one scenario there. Now, with regards to the unit, that's problematic because you don't know if it's trashed, if it's in good shape, what it is. So if it were me, I would tell the seller that unless I could see the unit, I would have to assume that it's trashed, and I will have to lower my offer and include a gut rehab because I can't see it. I have to assume the worst. The best case scenario would be to tell the seller, you've got to evict the tenant. But that clearly is not going to happen here. They're not going to get into an eviction or do anything to try to get them out since cash for keys didn't work. I think this tenant just thinks they can just stay there and nothing will happen. Now, if they sell the property, you're going to have to evict the tenant if you take this on. So another cost to add in there is the cost of the eviction. Now, the current seller has already lost rent on this unit, and that's his or hers to collect. But from your day forward, depending on your state, if an eviction will and a set out will take you 2 or 3 months or 4 months, you need to figure the cost of that, of not getting that rent, and weigh that against the fact that unless you're really paying cash, you're going to have to be paying on a mortgage. This is going to be a loss to you. So I would also tell the seller, I will buy it like this, but it's going to take probably 4 months minimum, probably more like 5 months or 6 months to get it cleaned up and rented again, and get them out and get it cleaned up and rented. So I'll need to factor that lost rent into this scenario. And I'll also have to factor in all the costs for the eviction and the set out. So that would mean you're now lowering the price of the property for these two reasons: for not the fact that you can't see the property and you don't know what condition it's in, and the cost of the eviction. You know, you can possibly ask the seller to go back one more time to the tenant and say, look, I have a contract on the property. The property is going to be sold. And the first thing they're going to do is start an eviction process on you, which if you don't move out, you will be set out and you will have an eviction on your record. You know, make it clear that this is going to happen, and then they're going to have a problem renting another place. Maybe you could, if you could reason with them, you could put a note on their door, you can include your phone number. You can try all of these different things, but at the end of the day, if it were me, I would be realistic and assume that all of these costs are going to be a loss to me. You have to decide in the end whether or not this is going to be worth it to you. Is this hassle going to be worth it to you for the property? And many times they are, because you can get really good deals when someone doesn't want to deal with the hassle, like this hassle of getting the tenant out. They're just not willing to get into a confrontation with them. One thing I would caution you to do right from the get-go is don't tell let's assume that you're buying the property and you are now dealing with trying to get the tenant out. Don't tell them that you are the owner. Tell them that you are the property manager. You could position yourself as the acquisition manager for the company, whatever that looks like. Just don't tell them that you are actually the owner or the owner to be of the property. That sets up all kinds of bad situations. So just keep it strictly business. Just be the new property manager or whatever you decide to be. But know that all things related to probate are ultimately going to go through the probate court. They're going to make these decisions. They're going to follow the procedure that's laid out in your state. But it's not anything unusual. And here in Kentucky, and my friends all over the country, investors all over the country, they tell me the same thing. It's just writing a simple sales and purchase contract. That's all it is. Know the laws in your state. Talk to your real estate attorney. They will be able to tell you about any nuances that might be in your state. Look up the laws in your state. You should definitely know that, especially if you're in a situation, which I've talked about before, where you are possibly an executor and you want to rent a property until you can get it sold. There are ways around all of these things, but you have to know the laws in your state. Now, don't forget to grab my freebie, my probate investing starter kit. I'll put the link in the show notes, but you can get that at probateinvestingsimplified.com/starter kit. So that's probateinvestingsimplified.com/starter kit. And also check out my course. If you want to work in probates, which I believe is one of the most profitable niches on the planet, you can check out my course at probateinvestingsimplified.com. So let me know if you have any questions about probate investing, if you have any questions about this specific case study. And in the meantime, I will see you same time, same place next week. Bye for now.